Hi, and welcome to another edition of the Trustcast show. We're really happy to have with us Paul Mersino. Paul, welcome to the show.
Thanks for having me, Zane. Happy to be here.
So, today's guest took over one of Michigan's oldest law firms, a 170-year-old institution at the center of the American automotive industry at just 39 years old. And then immediately went to war in America's courtrooms across the country, fighting the exact disputes that keep business owners awake at night. And we're going to get into that. Paul, take me back to the moment you knew this firm was going to be yours to run. What was the conversation that made it real?
It was a long process in some respects, just kind of working my way up the ladder. I started out in management by running our litigation group, which is the one of the biggest departments of our firm. And then I was elected by our shareholders to our board of directors. And then maybe a year or so into that role, my predecessor announced that he was going to be voluntarily stepping down and that there'd be a search committee to find his successor. And I threw my hat in the ring, and there's many people in my firm who would have done a fantastic job if I hadn't been chosen. But when I first found out, I was very excited. But my first thought that went through my mind was, "Now let's go to work."
Okay. So you came up as a litigator, someone who actually goes to trial, and now you're also running your 150 attorney law firm. When did you realize those two tracks were going to define your career, and how does that those are two completely different hats?
Yeah, it's interesting because I actually went to school to get a business degree, and I always thought I was going to run a business of some sort. My parents are entrepreneurs, started their own business, so I saw that maybe in my path. And then actually through a great professor, business law professor in undergrad, we started a mock trial team where we would actually go and try cases with a fake fact pattern, and you have witnesses and you try the cases, and I fell in love with it. So I instantly knew I was pivoting to go into litigation. So now, fast forward many years, it's kind of gone full circle where now I am running a business, and so it's been a really nice way to blend sort of my two passions and maybe my two skills of business and litigation. Now you are right though; they're very different mindsets.
Hmm.
It didn't take me long to realize that I'm starting to think more like a business person than a litigator. Not that one is better than the other, but they're sometimes in contradiction to one another.
You kind of, I would think, would be forced into that role because you're making so many business decisions. There's so many people counting on you to keep the ship heading in the right direction. Um, that's just my observation. So I'm going to put together a couple of questions about hypotheticals. So a top salesman just quit and is already calling my clients. What do I do in the first 48 hours?
Well, call your attorneys, call Butzel. The biggest question is, do you have a contract with them? And of course, it also depends on what jurisdiction you're in. So every state in America has different laws on what's permissible and what's not, and then every country has different wrinkles too. Hopefully, you have a non-compete with him, or at least a non-solicit that says he can't call your customers or clients. The reality is, if he doesn't have one of those, and as long as he's not stealing some sort of trade secrets or confidential information, competition is still legal. So it really depends on how you set yourself up for success before that day ever came.
So when you're talking about a non-compete, how difficult is that to enforce? Because I know in some jurisdictions, isn't it completely different than in others?
You're right, and it's changed a lot over the years. When I first started practicing 15, 20 years ago, they were much more enforceable or much more likely to be enforced. They were maybe in higher favor than they are today. There's been a little bit of a groundswell, and the pendulum swung a little bit where a lot of jurisdictions have said, we are not enforcing non-competes. So some states have no, they have prohibitions against non-competes. And actually at the federal level, the U.S. government talked about and looked into banning them altogether. They haven't, which I'm glad, not because I'm pro non-compete or otherwise, but I think it should be left to the states. So in Michigan, where I am, they're still enforceable, but It's forced businesses to be more reasonable about how they're employing them. So if you're trying to stop someone from ever working in your industry for the rest of time, probably not going to be enforceable. But if you do have a an actual business interest to protect your trade secrets, to protect your clientele, then you might get that enforced for a period of time.
So hang on, I just looking at my glasses and they're just really cockeyed on my head, and it's hard to be taken seriously when they're like that. So let me change glasses.
No problem.
Okay, that's better. So, how do I know if you said something about trade secret. So how do I know if they've taken a trade secret with them versus just being non-compete? What's the differential there?
So sometimes obviously if you've got secret blueprints or schematics or engineering files and they go off and they start competing against you with the exact same product or something that it's obvious from that. Quite often what clients will do is if they suspect someone may have done something nefarious when they left, they will have their computer forensically examined. And you can tell, almost down to the file name and the second that they did it, what they downloaded right before they left, whether they attached a thumb drive right before they quit, whether they were emailing themselves tons of documents. Now, to get a court to do anything, you're going to need actual evidence like that. But that's one way that companies will try to see if somebody has taken their information.
So what do I have? So if I'm a key employee, I worked in the medical device industry at one point, and I knew all kinds of information about our products and the way they were manufactured, and I have that information in my head, and so a lot of key employees know that they don't need a diagram. They don't need that. If they leave, they already have that information. They have it stored in their own hard drive. What about those kinds of instances?
Yeah, and that's where it gets really tricky because the company you left says, I know they have our information, but how do they prove that you're using it? How do they prove that you're disclosing it? That's actually one argument for non-competes is that we trained this person, we spent tons of money to let them in on the inside. We can't afford for them to go across the street, and it would be impossible for them to do the same job without using our information. Now, with that said, there's a general premise that you can't stop someone from working just because they learned something, and you can't stop someone from using just general knowledge and general experience they've learned. But if it's something that the company kept proprietary, had non-disclosure agreements with their employees, and then they know and can somehow show that that employee used that information for a competitor, they could get an injunction in that instance.
So, what's the fact? Excuse me. What's the fastest legal tool available to stop a former employee from doing damage while a case plays out?
So if you have actual evidence of an actual breach of some sort, you file what's called a temporary restraining order, or we refer to as a TRO. And basically that's where you run into court, and sometimes it's my clients calling me Thursday afternoon. By Friday morning, I have to be in court with this TRO. And you tell the judge, here's the evidence we have that shows more likely than not that we are correct. So please stop this person from working for this competitor, and it's usually for a short duration. In Michigan,
Mm-hmm.
court rules say that a court can grant a TRO for up to 14 days, I believe it is. So it's the whole purpose of it is essentially, in layman terms, push pause on whatever's going on. It then gives the court time to actually hear actual argument, see what evidence we have, things like that, to see if yes, this person actually is breaching or not.
So, my curiosity goes, so you've got 14 days. You're not preparing an entire case at that point. I mean, because that's not enough time to prepare the entire case. So, what do you prepare in those 14 days to say, okay, well, here's the real story here?
Yeah, and it depends on what the judge allows you to do. He might just say, you brought the case, show me what evidence you have here and now that you have any evidence at all. They may allow you to do some discovery. So they'll say, you've got 2 weeks. I'll let you depose, the person who left and maybe one other person at the other company. Might order the parties to exchange documents. Again, this is very fast paced, very kind of short notice. And then they have what's called an evidentiary hearing. Sometimes you'll hear people call them mini trials because that's really what it
Hmm.
is. It's you're going in, here's the best evidence we were able to put together in 14 days time. You call witnesses, you put evidence on the record. The judge doesn't make a final ruling then. He doesn't say yes, you breach or not, but then he can grant a preliminary injunction, which is essentially a TRO for a longer period of time. And then that will be in place while you then go through the entire discovery process, trial, everything else.
So, what mistakes do business owners make in the first week after some sort of trade secret problem that kills their case?
We've seen a lot of mistakes, which happens, But one thing is they think somebody left, but they've already IT already wiped their computer and put it back into circulation for someone else to use, and there goes a lot of the evidence you had. Sometimes they wait too long. They wait a month or two or more, and they tell us, we really thought the day after he left that this might have been the case, but we're just now doing something about it. And not to say it's impossible to do something at that point, but obviously the quicker you move, the better. The bigger mistakes are things they did before the person left. They didn't have a non-compete. They didn't have a non-disclosure agreement. To be considered a trade secret, it has to be kept secret. And some people
Hmm.
think they're doing that, but you get into discovery and it turns out they have these files sitting on their desks out in the open, or they emailed all of these things to clients or third parties. So usually it's the mistakes they've made leading up to the person leaving more so than the mistakes afterwards.
So, I'm going to shift gears a little bit, talking between companies. Someone I've done business with for years just breached a major contract. What's my realistic shot at discovery? I mean, at recovery, sorry.
Recovery. If they, I mean, look, contracts are meant to be enforced, and they generally are. So if you can show that A, they breached it, and B, you were damaged, um, in theory, you should be able to recover those damages. Now, that's sometimes it's actually harder to prove the damages than it is to prove that they breached it. But through discovery, and I mean, nowadays discovery is so thorough, you get emails, possibly texts, you get forensic copies of computers. Um, it's easier today to get information to actually prove your case. So, that's why I have a job, because people do recover on those types of things.
Do dumb things.
Yeah, well, we all do, unfortunately.
Yeah. So my business partner wants out, and it's getting ugly. This is a tip. I mean, you probably heard this. What does litigation actually look like when you have, this breakup? Well, it's almost like a family breakup. Sometimes it is actually a family breakup. But you have two business partners. They've been at it for whatever length of time, and they've just fallen out of favor with each other. And the one guy says, "This is mine." The other guy says, "I had this idea." And what does litigation look like in that?
Yeah, and we see it every day, frankly. And we actually even refer to it as business divorces because it's really
Hmm.
is a divorce. And just like a real divorce, there's the legal issues, there's the economic issues, and then there's sometimes a lot of emotions involved. And even with business people, even with highly sophisticated business people, there's still often a lot of emotions involved. Um, and you are right. I've seen more families than I would ever care to see get torn apart because of business going bad, and it's unfortunate. So, what does litigation look like? I always warn my clients, and we do both plaintiff side and defense side when it comes to business disputes. Um, we walk through what the process is going to look like. There's going to be a long period of discovery. There's going to be depositions. You're going to have to turn over all of your documents. They're going to have to turn over all of their documents. Nothing moves fast. The only things that move fast are those TROs I spoke about earlier. But with the
Hmm.
general, when you're talking about a breach of contract or a business divorce, I mean, litigation can take 2, 3 years sometimes. It's going to be expensive. I walk through with my clients exactly what, and it's hard to know upfront exactly what it's going to cost because there's so many variables. But we walk through what it might look like, what it might cost, and then I always advise them. A lot of clients say, "I'm going to do this on principle. I don't care what it costs. We're going all the way." I always advise them that the part they don't always anticipate is just how draining it can be for somebody who's going through that. You're being pulled away from your job. You have to go back and look at old documents. You have to be deposed and spend a day in a, windowless room and days preparing for it. And there's emotional up and downs. There's, a lot of times I tell my clients, you would be better off just go do what you do best, which is make money, make the product you make, provide the service you provide. Um, your time is not best used sitting in a courtroom or a deposition room. So I don't try to talk myself out of work. That wouldn't be the greatest thing, but I just want them to have a very clear picture of what it's going to look like and feel like. Now, sometimes they still, especially when things are brand new and the wounds are fresh, they still say, let's push forward. Sometimes we go all the way. I've tried many cases, and rightly so. But sometimes they have to kind of go through it to feel that pain, feel the emotion, realize how much of a time suck it can be. So there's the what you see on paper, and then there's kind of the, everything that goes into it behind the scenes.
So how do you, so the one thing that I could see that can really go wrong in the process is you have one person who really wants to just settle this and put this behind them, and then the other person feels like they've been wronged in some way. And how do you get that whole thing to work out? I mean, it's almost like you have to be a counselor. Uh, because these people on the one side, the one person may be really emotionally involved in this, and the other side, he's emotionally involved, but he's willing to do whatever he needs to do to make it work out. How do you make that work out without and encourage them to do it without going to court?
And it's not easy. And it takes a lot of discussions. And you are right. We refer to ourselves in my firm. We are a lot of our logos even say attorneys and counselors because there's that and counselor part is just as important oftentimes. So walking people through, and quite often, and again, this is a case even with sophisticated business people. The trial is maybe their first experience with the legal industry or legal process. It's confusing, it's frustrating. You don't have control. People like to have control, and this is one area where you have very little control. Judges are generally very intelligent people, but they make mistakes or they just see things differently than you see it. Juries are very unpredictable. So there's very little control. It's a lot of counseling, a lot of talking. Sometimes we'll go through mediations where you actually hire a third party who's an expert in these things, and he walks back and forth between both parties, trying to get them to see one another's position or at least find a way to resolution. But sometimes the clients have to, kind of live through it before they totally understand it. And sometimes always you can't predict what the other side's doing. And it is frustrating when one side says, can't we just be reasonable? And the other side just simply isn't reasonable. Then on top of that, you've got some attorneys who can be reasonable and some attorneys who can't be reasonable. So it's not fun. Litigation is not fun when you're the parties going through it. That's for certain.
So here's an interesting twist on this. So what do you do when it's your client who is the one that's not being reasonable? I mean, you always like to think, well, my client is in the right, and I'm sure you've had these where
Oh, yeah.
you go home at night and you think, damn, if we would just work and just give a little bit. How do you handle that?
Yeah, and it can be frustrating. Of course, there's lines that you don't cross. If they're asking you to do something that's unethical or anything like that, that's no, we don't do that. But at the end of the day, their litigation is their litigation. And if they might say, I'm not going to settle for a penny less than what they owe us, even though
Hmm.
they could get a really, even if it means they're going to end up spending more on legal fees because of whatever principle or they want to prove a point, things like that. At the end of the day, my job is to give the client the best advice I can give. And quite often it's, look, I think this is a really good resolution and you should really consider it. But then I tell them, but it's your case, it's your business. If you want to go forward, I'm here to fight forward with you. So it can be frustrating, but again, I view my role as to give them the best advice I can, and I'll be direct, I'll be straight with clients, but then willing to do what they are looking to do.
Yep. Yep. So you've gotten multi-million dollar verdicts and awards for clients. What separates the cases that win big from the ones that don't?
Well, the first thing to realize is that most cases, statistically speaking, do not go to trial in the civil world. In the business disputes like I do, something like 97% of cases, maybe even 98% of cases, settle at some point along the way. And frankly, it should, because for all the reasons we've already said, it's not the best use of their time. Often it's more emotionally driven than other things. Usually
Hmm.
there's a good business decision to be made before you get to trial. But then once you get to trial, boy, it's preparation, preparation, preparation. You might have a 1 day trial and you're preparing for months for it. Usually a trial of any magnitude is going to be somewhere between, look, it could be a day, it could be a month-long trial. It just depends on the complexity of it, how many witnesses there are, how many documents you've got. But it is all about trial, and that's what separates the winners from the losers more often than not. And it's all the decisions made. The litigation might last 3 years, but what you put in the original pleading matters, whether you got the right experts lined up matter, whether you asked the right questions at deposition matter. So it's kind of like doing a really big jigsaw puzzle for 3 years, and each piece is going to affect the final outcome. So it takes a lot of forward thinking around corners, thinking of how this move will set up the next move, and then just preparing like crazy.
So are most of the, if you do end up in trial, that 3%, are most of those bench trials or are they jury trials?
It can go either way. You have even with business cases, you have a right to a jury, but the
Okay.
parties the parties can decide to waive that. And there's a lot that goes into that. I mean, knowing your bench is part of it. Do you have a really sophisticated business judge? Or do you some judges are perceived as being more plaintiff friendly or defendant friendly, or there's a lot of different variables that go into it. But for myself, I'd say honestly it's been about 50-50 whether it's a bench trial or a jury trial.
Okay. So you've litigated automotive supplier disputes where the numbers went up to 125 million. What's it like to walk into a case with that kind of exposure on the table?
Well, it depends on which side of the table you're on too, right? But the reality is, in whether it's 125 million or for small businesses, 125,000 could put them out of business, and it
Right.
is sobering and maybe stressful when a client comes to you and says, "Look, if I lose this, I'm going to be out of a business." And sometimes it's a mom and pop company, sometimes they employ, dozens of people. It's always their livelihood. And that is a sobering realization that, what I do for their case could dictate whether they have a job and whether dozens of other people have a job tomorrow. So it can be stressful for certain, but it makes it even more of an honor to have the privilege to be allowed to help other people. And at the end of the day, that's what our jobs are. I know lawyers, there's plenty of connotations and jokes and perceptions, but at the end of the day, we are there to help people. We know that when people call us, they either have a really big goal they're trying to obtain, or they have really big problems they're trying to solve. So that's the way we look at it. We are a service industry. We love servicing our clients. We love the client experience. And we hope that when they walk away with the feeling that they took care of me. They had my back. They leave any conversation with us feeling more assured than when that conversation started.
So when you are discussing with opposing counsel and with, oh, sorry, my headphone fell out there.
No problem.
When you're discussing with opposing counsel, uh, the impact on your client and on their business, um, do you do that, or how often do you do that? And does that ever sway somebody? Because you're talking about people losing their livelihood and other employees potentially losing their livelihood. How do you frame that in such a way? I mean, because these are people, you're one person talking to another person. Ultimately, it's generally, you know, uh, one person or a small group of people who are making the decision, hey, do I want to pursue this, or do I want to pursue this to the maximum amount that I could possibly get, or do I want to give some mercy in the process. So, do you have those kind of discussions?
I certainly have. It depends on how well you know opposing counsel or what you know of them. They also opposing counsel might say, "Look, I feel for you, and I feel for your client, but my client wants to move forward, and I have a duty to do so." Some attorneys and some opposing parties that might sway them. Others might view that as there's blood in the water and they've got leverage over us and they're going to squeeze us. So it's probably more art than science as to when you would, use that kind of um, discussion point. So I've certainly had those discussions, and I've certainly heard other people have those discussions too. Even with judges, you might say, Your Honor, this is going to put my client out of business, and not because they're mean or cold-hearted, but sometimes they might say, I'm sorry, but the contract is what the contract is, and I'm going to enforce
Right.
it. So it definitely doesn't always work the way you might hope, but it's a conversation I've had before.
Um, so tell me about a trade secret case where the evidence against your client looked bad and how you maybe were able to turn it around.
I'm sorry, could you repeat the question one time?
So tell me about a trade secret case where the evidence against your client looked bad, but you were able to turn that around. Or if you have an instance like that.
Yeah, and all the time, frankly. And usually it's and usually it's not because they're trying to be sneaky or nefarious or evil, but um, sometimes honestly people forget that they took something home, or they downloaded something months ago for a very proper reason and forgot that they still had it at their house. So sometimes it looks like there's a smoking gun or they've caught you red-handed. That's when you have to do the job of digging into it, talking to your client. Why did you have this, or why does it look this way? Trying to convince the judge or the jury or sometimes the other side why it's right. To be completely honest, and maybe this will sound corny or trite, more often than not, I find that the truth is the best answer. And if it's
Hmm.
sorry, I didn't mean to do that, or here's why I had that. Um, Quite often, what I have seen this doesn't exactly answer your question, but to twist it a little bit, is when something happened that maybe wasn't that big of a deal. There was a document, there was an email, something like that, and then someone panics and they then delete it off their computer or delete emails or they wipe their hard drive. And the old saying, like, the cover up is worse than the crime. That often happens, and I've seen cases lost because whatever it was could have been explained, but then they went and destroyed evidence, which is obviously a big no-no when there's litigation going on. And it was actually because they destroyed the evidence that they ended up losing, as opposed to explaining whatever it is they were trying to hide.
When you get a TRO, is the first thing that preservation of evidence is there some sort of filing that you do there too as well?
Yeah, yeah. So you get the court to issue some sort of order preserving evidence. Anytime we have litigation, standard fare is, one of the first things you do is we actually send our own clients letters that say, here are your duties and obligations. And that obligation doesn't start when there's litigation or when a suit is filed. It actually
Hmm.
starts as soon as a party knows that there is a possibility of a dispute. So whether they've been told by a court or not, once they knew there was a possibility of dispute, they should have preserved all their evidence.
So so if you're thinking in the back of your mind there could be this dispute. I mean, as a business owner, and then you think, well, I'm gonna just get rid of these emails. There's nothing going on yet, but I think the safest bet is to just these emails maybe implicate me in some negative way. I don't think they're a big deal, but they might be. So I'll just go ahead and delete them. How does the court look at that? Is that almost like an indication of guilt? I mean, do they consider it that in that way?
Yeah, so there's actually a principle called spoliation, which is when you destroy evidence. And if you can prove that that happened, or at least get the court to agree with you that they purposely destroyed evidence for some reason, they can actually, whether it's, if it's a bench trial or if it's a jury, they can tell the jury, or they themselves can, um, there's a presumption that whatever was destroyed would have been negative for the person who destroyed it. So it's almost like you start two steps back, we presume that had that not been destroyed, it would have proved the other side's case. So it can be quite damning. That's why I say when something that otherwise would have been a small piece of evidence, now it's a presumption that you've done something wrong and you have to dig yourself out of that hole. So it can be quite damning to a party's defense.
That's enormous. I wasn't. I mean, I really never thought about that. So I would think that there was that would happen frequently, or
It's proving
potentially
it,
happen.
right? You have to prove a negative sometimes. We know they had this document, but now it doesn't exist, and you have to kind of try to prove. Now it's gotten easier to prove because of forensic evidence with computers, things like that. So it probably there's probably spoliation more often than it gets caught,
Oh,
perhaps.
right.
But yeah, if you can prove it, it can really change the outlook of a case.
So here's something that most people would be interested in. You filed an amicus brief on behalf of Chris Kyle's estate in the American Sniper lawsuit. What was that experience like? I mean, that's a high profile case known probably around the world.
Yeah, so just for those who may not know it, very briefly, Chris Kyle was from the book and the movie American Sniper. Bradley Cooper played Chris Kyle in the movie. Chris was a Marine and he was a sniper, and that was his job in either Iraq or Afghanistan. I don't recall right offhand. Um, Chris came home and he wrote a book, and in that book, he said something. He didn't even name who he was talking about, but the implication was that he was talking about Jesse Ventura. And basically, in the book, he said he knocked a guy out. It was another former military person, and he punched him and knocked him out. And so after the book came out, Jesse Ventura sued Chris Kyle. Tragically, Chris was murdered, and I didn't know Chris for the record, but Chris was murdered. It's a really sad story. So now his wife is widowed. You know, he goes through 3 or 4 tours of active duty, fighting for his country, makes it back alive, and then he gets murdered here in the States. Um, Widowed his wife. He had 2 young kids, and you or I might think that most people at that point might drop the lawsuit, but the plaintiffs did not drop it. So the case went forward, and Chris Kyle's estate, so meaning really his wife and his kids, had to pay an enormous amount of money. They got a judgment against them. So they appealed it, and it went up to I believe it was the Eighth Circuit. So how did I get involved? It was actually I watched the movie American Sniper with my wife.
Hmm.
It was a great movie, very well done. I was moved by it, by Chris's not only his service, but just what happened to his wife and his kids, and to him when he came back home. And I was just moved by it. I was sad, so I started just kind of researching online, like to get more of the story. And I find out about this lawsuit. And I was just sort of angered by it. Like, this poor family is going through losing their husband and their father, and now they've been sued for all this money. And it was one of those instances where you think, like, I wish I could do something about that. And
Yes.
and I realized, well, I'm a lawyer. This is a lawsuit. Maybe I can do something about it. So I actually just reached out to the lead counsel on the case and introduced myself and said, if there's anything I can do to help, let me know. And they were very well represented. But then I realized that the court was accepting amicus brief. So an amicus brief literal translation is friend of the court brief. So
Hmm.
it's when somebody who's not a party files a suit saying, hey, court, I think this is how you should rule on this case. So I filed an amicus brief with the Eighth Circuit. Now I take no credit for the outcome by any means, and there was wonderful attorneys working on it and smart judges, but they did overturn that verdict. And in the judge's ruling, it actually quoted verbatim some of the language I had in my brief and some of the cases that we had cited that others hadn't. So I'd like to think that at the very least we were on the right side of that outcome, and maybe we played a really tiny role in getting that judgment overturned. It was actually it was then sent back down to the trial court, and they ended up settling outside of court and outside of the public eye. So I don't know the final results, but we got that multi-million-dollar judgment overturned.
Yeah, that seemed like just a tremendous injustice. So um, that's just it's a great story. So you won at trial level and then had to defend those wins all the way up to the Michigan Supreme Court and then the Federal Court of Appeals. Walk me through what an appellate fight looks like.
It's much different than a trial. A trial is more kind of a fist fight, whereas, proverbial, of course, figuratively speaking. But you're trading barbs. He said this, she said that. You've got to be really fast on your feet as a trial attorney. Things just move extremely fast. Appeals are a little bit more, scholarly in nature. It's really when you get to an appeal, it's basically everyone has to agree on the facts because they are the facts that were presented down below. You can't bring new facts into the appeal. So now you're just arguing the law and the application of the law. It's a little more erudite, more scholarly in process at the very least. But I enjoy it, and it's really fun when you have oral argument in front of a judge because with a jury, you're kind of telling them your story. You're being a little bit of a salesman, if you will. But when you have an oral argument with your judge, and this happens at the trial level too, from various times, but it's the judge is grilling you and asking you questions. Well, what about this? But you said that. But they're asking you about facts from the cases you pled. It's you really, I mean, again, preparation, preparation, preparation. But it's more of a kind of a scholarly mano a mano with the judge. And I had one time I was out in the federal court in Utah, and I think I stood there at the podium for about 2 hours with the judge, and he was just peppering me professionally and everything else. But it was kind of a marathon of just me and him, and you're kind of up there on your own. So I enjoy appeals very much.
So most people don't understand the whole process of an appeal. So let's say I'm taking something on appeal, and there is a important piece of new evidence that really change the reflection of the case dramatically. Um, can you introduce that at any point?
Generally not at the appellate level. If there was something that was, say, it was hidden by the other side and that's why it didn't come out, you would actually go back to the trial court and say, we want to reopen this case. Generally speaking, and there's always exceptions and loopholes or things like that, but generally speaking, on appeal, you have the record from the trial court. So that's why they tell attorneys you have to preserve that record. Sometimes you make arguments at the trial level, they're going to lose, but you make them because you want to preserve that for the appeal. Or there's certain facts or evidence you want to introduce, and the judge is probably going to not allow the evidence to come in, but you try anyways, and you make an offer of proof as to why you want to enter it because you're preserving the record for appeal. Then when you get an appeal, you've got your transcripts from the trial level, you've got all the evidence that was introduced at the trial level, you've got the judge's rulings from the trial level, and for the most part, you are limited to that. So if you try to bring up something new at an appellate level, the court will, first thing they're going to ask you is, well, why didn't you bring that up before? Or why didn't you make that argument at the trial level? Or why didn't you introduce that piece of evidence at the trial level? So again, I'm not saying that you can never reopen a case if some huge piece of evidence comes out that would change the entire outcome. But again, it also has to be because you couldn't have found it for some reason, not just, oh, hey, I forgot to ask this question and later we found something new out. So it's and that's why a lot of really good attorneys will have appellate lawyers. Some people do both. Some people do trial work and appellate work. But those who maybe don't do as much appeal work, as they're going through their litigation and their trial, they'll have an appellate attorney work with them because they can say, hey, here's what you're going to need to preserve. Here's a way to make that argument so you preserve the record for the court up above. And then appellate courts generally, again, generalization, but appellate courts are really looking at legal issues. So they're not looking at did that person do it or he said, she said, and we're going to decide who we believe. They're for the most part looking at legal issues. So did the lower court judge properly admit that evidence? Did the lower court judge properly exclude that evidence? Was this case properly ruled upon? But it's more legal in nature as opposed to factual in nature.
Right. It's an interesting nuance, or even much more than a nuance, but most people aren't aware of that. So, are you still actually, having my research, you're still taking cases while running a 150 attorney firm? Is that true or is that not true anymore?
It is. I'm not working trial work as much as I used to because obviously I'm running a large corporation. We're actually closer to 175 attorneys now and have close to 300 employees overall when you talk about legal assistants, paralegals, all the people it takes to run a firm. Still very involved. My clients still call me. I'm still there for them. Generally speaking, though, maybe where I would do something on my own before, I'm going to have
Hmm.
a team now and make sure that, we've got everything covered just because of my schedule and hours and everything else.
So, who's your ideal client?
One who pays their bills. You know, um, clients come in all just because they're people, right? And people are all
Yeah.
different. I do appreciate it when a client trusts me and takes my advice. And I tell them, you can do what you want, but you're paying me a lot of money for my advice and my experience. And here's what my advice and experience says. They can disregard it if they'd like, but it is nice to have a client who trusts you, is willing to follow your lead, an honest client, frankly. Well, that's pretty key to me. There's nothing more frustrating if you have any inclination that a client's not telling you the truth or hiding something. And I can't say that's happened to me much, but an honest client who's willing to trust you. And then to me, we're a team. A lot of people don't like lawyers. A lot of business people don't like lawyers, even their own when they hire them, and they almost want to be antagonistic towards you a little bit, and that's fine. But my view is, look, we're a team. I'm here to help you achieve your goal, or I'm here to help you solve your problem. How can we do that together? Work together. So I guess it's like just about anything else in business or in life. You want cooperation, and you want everyone just kind of row in the same direction and on the same page.
So, Butzel really specializes in commercial law. I mean, you're not taking on other things outside of that window. It's really just within that window. Do you also? I guess that's the question first, because then there's a second part to this.
For the most part, that's the vast majority. I mean, we don't do personal injury, we don't do medical malpractice. Now, we do white collar criminal defense. We do investigations and regulations. So a company needs to investigate whether something happened within their company. We help with that. White collar criminal defense, we assist with that. We have a very large immigration practice. Now that's usually what I'll call business immigration. We're representing the company who is trying to bring someone over on an H-1B visa, for example. And we also do estate planning and kind of high net worth representation. Usually that's for an executive who is also, their business is a client type of thing. But
Right.
you are correct that the vast majority of what we do is what I always say, if a business needs the service, we probably have it. Commercial litigation, corporate mergers and acquisitions, labor and employment. Again, if a business needs it, for the most part, we provide it.
What's your geographic footprint?
We've got 9 total offices, and 8 of them are in Michigan. So we were founded in Detroit in 1854, and now we've spread out throughout most of the state of Michigan. And then we also have an office in Washington, D.C., right on K Street.
Is that because so many issues are federal in nature?
Yeah, and you've got, federal regulatory bodies that our clients need to talk with. Yeah, there's a whole lot of that going on.
Now, if somebody's in Ohio and they have something that they say, I've got this commercial thing, but I think Butzel is uniquely qualified to help me. Can you practice like that?
Yeah, and I've tried cases Utah, Omaha, California, Texas, Florida, Ohio, and many other states, as have my partners. So the way it works is, I'm licensed in Michigan, but if that
Hmm.
instance happened in a state where I don't have anyone licensed, first off, I have lawyers in my firm licensed in many states, even if they're not where they live. But what I would do is I would work with an Ohio firm or an Ohio attorney who acts as my local counsel, and then I get admitted on a basically a temporary basis. I'm admitted to the courts of Ohio for the purpose of that case. So we've done that all over the country, and that happens sometimes. We have kind of a unique comparative advantage or unique expertise in automotive supply chain work because we're in Detroit and Motor City. So we work with a lot of auto suppliers, and they'll hire us anywhere in the country. We do a lot of class action defense, whether it's on the product side or sometimes that's automotive related. We've done a lot of cybersecurity breaches, defended against class actions in that front, and we'll get hired all over the country to do that.
So you're generally working on the plaintiff side,
Um,
or I
it
mean
really
the
depends.
defense side.
So more so on the defense side, but again, when
That's what I meant to say. The
yeah,
defense.
no. So I mean, on the class action stuff, yes, solely on the defense side. But if it's a breach of contract, we'll be on either side of that. I've been on both sides of non-competes even. So if it's more just a business litigation matter, we might be on either side. But we always represent management or companies, not the individual who's suing them.
Well, Paul, that was a really interesting conversation. I appreciate you coming on the show. If somebody does have an issue of commercial in nature, or that's in Detroit or the Michigan, because you're in, like you said, you have 8 locations in Michigan, and they need some business help. How do they reach you, or how do they reach your firm? Because they're probably not going to get you on the phone, I bet.
Oh, they'll get me if my phone
They
rings.
will. Good.
Yeah, they'll get me definitely. But check us out at butzel.com, butzel.com. My email is last name Mersino at butzel.com. And we are happy to help. And one thing I will point out is something we stress, and this goes to your point of, I would absolutely answer a call, text, or email as soon as it comes in. We really stress client service. We know when people are calling us, it's because they're maybe having the worst day of, their month, if not their life. And we really want to obviously we want to win. But there's a lot of smart lawyers, there's a lot of good lawyers where we set ourselves apart as the client service and just doing whatever it takes for our clients. So we'd be honored to help anyone who needs our help.
So, how do you market your firm?
I've got
What's the
I was gonna say I've got an amazing marketing team. So my we've just changed the position a little bit. My former chief marketing officer, she's now our chief experience officer, our CXO.
Yep.
And her job is really to be the point of contact for those clients, reach out to those clients, work with our existing clients to make sure they're getting everything they need. And then we're, same as with everyone, we've got a web presence. We do a lot of print ads still, podcasts. We're everywhere, and that's because we've got a great marketing team.
Fantastic. So, thank you so much for coming on, Paul. I really appreciate it. I think our audience will enjoy it as well.
I hope so.
So
I